close today's plenary session, we'll continue with regulation challenges on product safety, protections on existing regulations, national, international, and compared gaps and new matters to address in the future. The moderator will be Diego Martínez, researcher, attorney of the programs on consumption rights at the University of Chile. He's a researcher of the program on right of consumption at the University of Chile. He conducted research on all matters of this area and has focused on inquiring matters on children and adolescents as consumers and their vinculation in other matters, such as the case of toys. Our speakers are ready, and if you have any question, please use the website as well as the QR code behind your credential, please. Thank you very much. First, I would like to thank the invitation by SERNAC to be the moderator and sharing this instance with the distinguished national and international colleagues. And using these instances to share with you is something very valuable. In second place, the topic of this table, I would like to say that in Chile and other legislations, probably you said this before, safety is a basic right, as it is information, free choice, among other rights being part of the catalog of basic rights of consumers. And that's where the important lies. There are some authors who have considered this type of basic rights is not only about intention declaration, but they are fundamental subjective rights laying the foundations for the consumer's protection. In Chilean In Chilean legislation, in compare right, we will find the enshrinement of the basic rights, and also in our country, we can connect it to products and services, and we'll find some special matters, for example, parking or toys, which are targeted to a population that's been vulnerated in our society. We'll have to talk today about product safety, and we have an excellent panel here. I would like to introduce them. First, Professor Erika, Doctor in Law, Director of the Space Regulation and Consumption at the Autónoma Universidad of Chile, distinguished academic, Mr. Ricardo Salazar, President of the Defense of the Consumer from El Salvador, and Mr. Guillermo Guzmán, Head of the Interpretation and Legal Interpretation Department of the Consumers Association of Chile. We'll start with the presentation of Erika on the challenges around the dangers to the integrity to the guardianship mechanisms. Good evening. Thank you very much to the SERNAC for this invitation. I thank Mr. Andres Herrera, National Director, as well as Daniela Parra, the Head of Safety and Sustainability. I'm very glad, not only an honor, but also I'm very glad to be here. I worked 4 years at the SERNAC, so I feel affection for the SERNAC, and I have been able to see my workmates back then. My presentation will be available for you. If you want to have it, I can share it through email, or maybe you can ask the organization to share it with you. I was asked to make some reflections around the challenges of the Chilean legislation around safety in consumption. And challenges, well, they are huge, and some of them are related to some deficiencies in our law. In matters of safety in consumption, we should distinguish two areas. The first one is prevention, something been talked about in the previous panel, and it's about the prevention of damages through some guardianship mechanisms such as recall, surveillance, safety alert. And the second area is repair, which is a responsibility that comes after it, once the damage has been done. And in terms of safety in consumption, what's important about it is, unlike quality, the legislator seeks to establish these two mechanisms. In matters of quality, we only have the ex post guardianship, which is the guarantee. But in terms of safety, as a protective legal asset, we have these prevention mechanisms. And in both cases, we have challenges. Today, I will focus on the first ones due to time constraints, since we have only 10 minutes and a clock that's been ticking for some time so far. But I would like to tell our international colleagues, but in repair matters, we do not have a law on that. We know other countries do have that. A little time ago, from Colombia, she made a presentation, and the statute of the consumer has some norms around that. The Brazilian code also contains that, and the Chilean case, our law on responsibility per product is in the sanitary code, and it's pretty nascent. It's new, so the big challenge on that, I won't refer to it due to time, is about this debt around this compensation action called safety to responsibility per product. I will refer to the first ones, which are the guardianship mechanisms. Maybe you can help me pass the slides, please. Which are the prevention and schematized mechanisms under three important groups of mechanisms, which is surveillance, alert or warning, then the establishment of safety. A brief configuration to understand the deficiencies in our law, which has been compensated by the actions of the SERNAC and somehow by the best practices of some companies, as we have heard some time ago. The first prevention mechanism is surveillance. In this case, the company, what it has to do once the product is in the market is to continue inquiring and understanding what happened with their product. We have passive and active surveillance. The passive one is once the product is in the market, they continue doing some research. It may cause some damage or not. There are some unpredictable damages, of course, but once the product is launched, we continue inquiring on what happens around safety. And then we have the passive one. The prior one was active. Passive one is about receiving reports. They may be from the mass media. We know that in the Chilean case, during the pandemic, there has been a lot of safety alerts from social control. The food producing dogs dead, that's through a social control. That's also a passive surveillance case. The manufacturer receives the information from the citizenship, from a study center, or from a university, and so on. At present in Chile, surveillance is being regulated based on the pharmaceutical products, which is called pharmacy surveillance. In other products, this is not surveilled on a guardianship. The second one is warning, and this is why, by this we mean safety alerts. Once people are familiar about the defect of a product, then comes the mission to alert. There are some flaws here. And finally, not only alerting is enough, but also we need to reestablish safety. And how can we do that? How can we do that? It depends. One's possibility is instruction. For example, by informing the consumer that the product should not be used in one way, but in another one. Netflix documentaries showed one of those things. Maybe you have seen something about the IKEA furniture falling down on children's bodies. One of them was instruction: use a hook behind the piece of furniture. And then we have another one, which is the recall. In this, we withdraw the product for what? For repairs, it might be also for refunding in case, or reimbursement, or a compensation if there have been some damage to consumers. In addition to that, some other guardianship mechanisms which has been assigned in the law, correction measurements, and then some ongoing actions. What are the challenges this protection law tell us in these 3 points? And in my opinion, although the law is not enough, we can see that in practice it's been being more or less compensated by the SERNAC actions and also the company best practices. But SERNAC have reacted by demanding what, in my opinion, would be pertinent. A first challenge has to do with the following. It's about yeah, you can tell me about the time, please. Our first challenge is about the origin of the guardianship mechanisms. Daniela talked about the regulation of the guardianship mechanism, and if we understand it literally, we may understand that the recall of the safety alert would only proceed first if toxicity has been declared by a courthouse or when it has been ordered by a competent authority. Neither the law says competent authority, which has been compensated, as Daniela has said before, by estimating that the competent authority would be the sectorial organ and the SERNAC additionally, but the regulation doesn't state so. The problem here, in first place, lies in we do not know first if we should obey the law itself in those cases where toxicity has not been declared, whether we should have the mission or whether they should have the mission to do the recall and to issue the alert. In my opinion, the Articles 49 and the coming one does not contain that, but we can start in the letter D in the norm referring to safety of the product. Even in the absence of a general regulation, in my opinion, safety to consumption safety should be stated for something that is not typified in the law. Leandro Contreras said to us, it's imperative to do the recalls and the alert despite we know that according to the literal order, a possible interpretation, the one I don't agree with, it wouldn't be an obligation. A second point, a second challenge, has to do with the temporary efficacy of these guardianship mechanisms. In what sense? The law does not regulate until which extent we should make the recalls, alerts. Then a first interpretation, the one I don't agree with, should be to claim that preventive guardianship mechanisms are subject to the repair responsibility, Article 26, 2 years of infraction, and then common deadlines. This is a silence or a loophole in the law, according to what Leandro Contreras has said before. In Weirland, he said, the preventive duty, we understand it as an active one until the product is in the market. That's not clearly in the law, but it's been solved in the common law when we have these preventive laws in the ownership actions. It should be extracted from there to the common law. What happens in the case of the Consumers Protection Law? A possible interpretation I disagree with, that's a challenge in matters of protection, is to understand that it is subject to the deadlines of repair responsibility. One deadline expire in indemnization, then the supplier shouldn't have the duty to formulate the safety alerts and the recalls. In my opinion, that interpretation is incorrect. This loophole might be compensated through an interpretation of the law adjusted to this right to safety, through which, while the product is on the market, the duty still exists, and that evidences another characteristic of the preventive duties, and its autonomy. Preventive duties are autonomous compared to repair responsibility. That is, it is possible that repair responsibility is extinguished, but the preventive right still exists. The motives, it depends. Let's imagine the legislation allows the extension of responsibility through development risk, something that in protection to the Chilean consumer in general terms is not regulated. But let us imagine that it is like that. If the manufacturer could be released from responsibility due to development risks, that means they will not respond for the past or current damages the product may have caused, and once he is aware, they are aware of it, they should emit that alert. Whether they do not do that, in that case there is a non-compliance of their duty, not the original product safety, but the non-compliance of the alert, prevention, and reestablishment of safety duties. Same happens with the distinctive prescription. If the responsibility, civil responsibility, should be expanded, the since they are autonomous mechanisms, then under this context, this responsibility emerges again through the non-compliance of the alert.
2 minutes, thank you. That's when it comes to temporary efficacy. And another unsolved point through the legislation is the matter of application. Can we move to the next slide? Towards a picture that's just up there with the news. It has to do with the determination of the application of the recall related to information. We know already that when it comes to reestablishing safety for consumers is informing the consumer, and the other one is recalling for repairing or compensating the consumer. This is a topic that is generally not solved because by Chilean legislation, except for a court-ordered recall. There we go, that one right there. The only case where it's been solved, this limit between informing and reestablishing safety via recalls, is the one where toxicity has been declared by a court. It's evidently between two options, between informing and changing product. The cheapest alternative for the manufacturer is just informing. And this is not about, we of course need to safekeep the public order when it comes to economic matters. We can't always order recall and change as long as safety can be reinstated through information. This is something that is not solved in general terms, in my opinion, in legal matters. But the solution that was established by Professor Lautaro Contreras, and with this I'm wrapping up, he says, look, let's use the criterion of the constitutional principle of proportionality to determine the boundaries between one and the other. And in this context, to me, it seems it's very enlightening, the sentence that was pronounced when we talked about these malfunction in pacemakers by the European Union. This case, it was very brief. It also affected some Chileans. A company that made pacemakers and defibrillators, once the pacemakers were released into the market, and after many of them were implanted in consumers, they realized that they might not work. So this sentencing is very important for three reasons. The first one is because the court determined that it's not necessary for the product to fail for it to be faulty. Because if we need to wait until a pacemaker malfunctions, then the people will die. So it's enough with the threat of malfunction to establish a boundary. And the limit between recall and information, it's very coherent with the theory of Lautaro Contreras, where he says, look, we need to distinguish between a pacemaker and a defibrillator. Because the pacemaker, I can't solve it through informing people. I need to change it. Meanwhile, the defibrillator can't be maintained and implanted on people if we change some certain usage parameters. In that case, we don't need to reimburse people with money for the defibrillator. There's a criterion there that has to do with effectiveness, and it's adjusted, of course, to certain vulnerable people. For example, products that are directed towards children. In that case, independent of cost, independent of the way of it being resolved, we need to privilege a recall or a change. Thank you very much. Thank you, Professor, for your very interesting presentation. Up next, we're going to give the floor to Ricardo Salazar, who will present Strengthening the Consumer Protection and Product Safety in El Salvador. This will be presented by Ricardo Arturo Salazar Villalta. Hello, 1, 2, 1, 2. We just came back from the break. It's 5:25. So I'll try to have you guys not falling asleep on me. It's a pleasure to be here sharing with this important instance where we look towards motivating countries and for everybody to pay attention to the regulatory matters. I am the president of the Consumer Defense Department of El Salvador, and I love being here in this city. I am very fond of it because it's the first city that I visited 24 years ago when we were discussing consumer protection issues. A few years back, there was an international consumer protection agency here, and I had the privilege of assisting. It was 1 week that I was here. My first mission was to be here and present myself. So that led to a history that has given me a lot of satisfaction. That already ate up a whole minute. What does the defensorship do? What do we do when we're protecting consumers? I would like to let you people know the following. I don't know. What is it with this? They told me that I just point and shoot. There we go. The first thing is that the consumer defenders, we are the ones that lead consumer protection services, and there's a couple of key numbers here. We basically work as attorneys for consumers. We have a DA or a lawyer. I studied economy for over 20 years, and we tackle all sorts of topics. But the truth is that we are performing important work. We have a sanctioning court, both in person, and the court are designed by are designated by the President of the Republic. I've had the honor of being in charge of the defensorship for over 7 years. I have been working with the government of my country, and it's been an honor to join both of President Bukele's cabinets. And here's a demonstrative amount of numbers to show you what we do. Of course, every country has different habits and different numbers. We attend consumers, we train them, we perform inspections, we recover important amounts of money. These are yearly digits. We also sanction, and the sanctioning court also develops solutions. There's also a great variety when it comes to alerts. We have alerts for toys, for home implements, for electronics, for tools, for handbooks, for kitchen appliances, all kinds of things, just like many other countries do. Now, how does this story come up, which is related through the regulatory framework? Like many other countries, we had a weakness. Before that, out of these 76 alerts, only 15% of them we found the product in our country. And we've emitted over 526 information requirements to companies, of which 90% have replied and over 10% have not replied. This story comes up in the year 2005 when the defensorship is created. And while we have an article that is linked to safekeeping the life of the population and not selling products that could put the population at risk, the truth is that we had a weakness, that a regulatory framework did not cover all of the necessary elements in order to have a regulation that could enforce and make it compulsory for manufacturers, that would have competency and not just the obligations. And these are the procedural times that are key, and it's time that allows the measurement, the objective measurement of the participation of the providers and, of course, by the institution. By 2015, the resolution was passed in our constitutional hall that allowed us to emit sanctions because it wasn't specified yet. a clear and detailed sanction when it comes to product safety. And by 2018, we managed to reform the law by incorporating a special disposition for this topic. However, there was the weakness that the entirety of the regulatory body of work was not fully developed, all up until June of this year. The second administration of President Bukele has approved a very important reform where over 50 articles of different competencies. To give you guys an idea, the consumer protection law has over 160 articles. 50 of them we've managed to reform them. We basically renovated the judicial framework of this. And something important, this is comment, it's going to take me 15 seconds, is the following. In that new regulatory framework with all these reforms, we asked for more. We asked for the necessity of doing more for our people. And it was part of the representatives of this institution brought these kinds of projects to the executive powers, to President Bukele, and tell him, look, we need to do more for our population, but I need resources. So 50% of the fines that came from this reform strengthened the capabilities of our institution. So not only do we want to do more, we need the resources to do more. And that is something that has allowed us today to have this framework in different matters. But I highlight product safety, where we have these 9 articles that we've developed, the mechanisms to act on this. With the knowledge of an international alert, for example, in the case of the defensorship, and the communication on behalf of the providers. We establish a mandatory time frame. They need to report in 48 hours after finding out about the risks of a product. We have the mechanisms to identify the supplier, to describe the risk in matters of product safety, write the effects that it has, its geographical location, where the product could be causing these effects, and we also articulate the indications and the measures adopted to correct these flaws in risks. And also in the cases where something has happened, we can describe the associated accidents to these dangerous products, and we incorporate an articulate of 2 important plans, one of dissemination and one of customer service. It's important to mention that in the case that there is a recall or product change in these kinds of situations, they need to notify the customer that indicates the place and date and conditions of this happening. Then we also have the amplification process when we terminate alerts, and also for non-compliance, part of our legal framework, and how they must be done and what moment it culminates, and the obligations of the supplier and provider. And also we monitor the compliance through 2 dispositions. One is the number 5 on Article 44 that talks about not complying with any of the obligations that are established on Articles between 10A and 10E of this consumer protection law. We do not leave any sort of loophole for suppliers or providers, and we also establish that they need to put and store products. There's a lot of protections there, and these sanctions can go from up to $80,000 fines. So we have this new framework, that allows us to develop our activities with full knowledge of rights and the law, that we've informed the suppliers, and up to this date we've been in this phase of promoting and informing people so we can let them know about this disposition. And as always, of course, there are some challenges that we have in front of us. We have 50 seconds still, so we're going to talk a little bit about the challenges. We need to guarantee that the consumers don't have availability of products that could be a risk for them. And we also need to do an internal coordination with the state. We have a work table here that's very interesting, that I feel it's a very clear measure of how the government should act, like what Chile is doing. This is something that we could emulate that could be very important. 15 seconds, next slide. That's it. There's the Defensorship's website, and of course our account on Twitter, formerly known. And thank you so much. Thank you, Ricardo Salazar from El Salvador. Up next, the floor is for Guillermo Guzmán, head of the Department of Judicial Interpretations and Analysis from SERNAC, who is going to present the safety challenges in foreign platforms. Hello, good afternoon. First of all, I want to say hi to all the present authorities and the officials of institutions that join us today. Closer to the mic, please. Seems the microphones are not my thing. Well, the goal of my presentation is to talk to you about the regulatory challenges and, above all, an important topic towards the future that could happen in Chile and throughout the region. This is the problem surrounding electronic commerce in international platforms. The most known are AliExpress, Temu, and we will be talking about that as the presentation goes on. It's clear that e-commerce has increased considerably in the last few years. Right after the pandemic, there was an astronomical increase in transactions done in e-commerce internationally. And the platforms of international commerce opened up to the possibility of selling products directly to the consumers and to conceptualize what we understand as international commerce are these transactions that are done by the consumer and have the features of being a cross-border trade. So the service provided happens outside of the international borders. In that sense, we can define certain problems or characteristics that are common in the region, especially because consumers have a relationship with a provider that is somewhat distant territory-wise. There are different regulations for those who perform commerce in Chile. So while having regulations and by being outside of the country, we have two statutes or two different regulations. Ones are the ones that apply to the provider and the other one that applies to the consumer. And usually, and in some cases, we'll have regulations that are unequal, so we may be unable to enforce certain protections. There's also the problem of enforcement on regions that don't really represent great comparative volumes of purchasing power. For example, if we compare Chile with the United States or the European Union, the difference in numbers would be too great. So we have the need to regulate the countries that have less purchasing power comparatively. And there's also a limited state control. We cannot think that customs services will receive an exacerbated amount of resources, especially when dealing with the search of products that don't satisfy the needs of an entire country. All these characteristics say that being able to regulate this kind of commerce is very difficult.
By being clear what the above said, I will briefly explain the operation of these platforms so that we can understand the regulatory challenges. Generally speaking, these platforms are under a marketplace model. That means that these platforms gather a buyer, it's a platform, and then we have a consumer, a sort of model, a three-party model. The provider of goods and services has an outstanding participation. Platforms usually regulate beyond the transfer of the product, and we should understand that in some cases there's certain responsibility. Besides, regarding the item, This is an important item because products can arrive at destination between 3 or 5 days. There has been even decreased. Some of the products are in 2 hours time in your house, but international commerce we find a lag between 2 weeks and 2 months. Why do we tolerate that, and why do consumers want that? Because it's due to the price, the low price, and the versatility these platforms respond to. And at present, in Chile at least, in a couple of months, there's no taxes, there's no custom duties limiting these purchases. Regarding the dispatch, generally these products are delivered through couriers or the postal code of pace. There is like a responsibility transferred, and we have seen this in some Chilean cases, where they have the specific responsibility with these suppliers, and then the model ends up resting in some countries regarding the state post offices. And in case there is a conflict, the solution will be only integrated by the platform, and then we can detect different problems I will refer to later. And the conflict resolution is limited to what the seller and the platform can say. By being clear of the main characteristics, we will see the problems. In first place, we have inaccessible rights. It's difficult to exercise legal guarantee or regret in some latitudes. There are some barriers in case there are products returned, for example, from Shanghai, and it will be very difficult to return that product and finally have a refund of the money. This is why people cannot exercise their rights when lacking the protective agencies to stand up for them. There are no certified products. In Chile, we have labels regarding appliances or any type of electrical appliances. And what happens here, some products are received that in some cases might be could not cause any damage, but others will do that. There are some irrefutable solutions. Probably there will not be appeal. There will not be an exercise of law in terms of not compliance by the suppliers. And there is also there is an important attempt to limit this type of the consumption, but there are some gaps when they continue to enter in the country these faked products or knockoffs. Regarding this problem and how we at the service are trying to tackle what's happening in Chile, I could say that there has been some complaints, related complaints. In the case of AliExpress, we have received 1,895 complaints related to it, and since they are not validated suppliers, we need to do a sort of search of where to find the real complaints. And in this case, we bump into some complaints where the consumer cannot complain before AliExpress by naming it or not, but mentioning the case, and in terms of search, that causes different responsibilities. In case of other platforms such as Shopee, we have 181 complaints. In the case of Temu, 379. In the case of Shein, 981. It is important, and of course, it's an unnecessary work to find responsibilities, that's for SERNAC, and make these platforms respond to it. In regulatory topics, although until this year, 2024, there was no specific regulation regarding this matter, we need to understand that the Chilean regulation, rather than theoretical problems where it can apply or cannot apply and provided exists or not, the importance is in the practical terms. We don't have addresses, we don't have any goods to seize, and then we cannot conduct any other activities. The only legal modification and important we have had in the last year is what's related to the law of tax compliance. That law will be applied as of 2025, will make vendors paying taxes on added value, and in somehow their actions could be controlled. Irrespective of that, we need to understand that this law will not necessarily favor the consumers' rights. There will be addresses, some vendors will pay taxes through the mechanisms of method of payments. But the problem will still be extensive, and we as a consumer service, we need to pay attention to that and tackle those regulatory challenges. I'm running out of time, so I will advance my presentation. Although we may see that there is a lack of regulation, we may also make a comparison with what's happening in the European Union. At present, and I would say as of 2022, there is a law of digital services trying to find responsibility in these digital platforms, and some points making suppliers to be registered before the European Union. The idea behind this proposal is that we may force that Latin American legislations do the same, so that we can make these vendors to be registered in the countries, so that we can finally find protections for uses which are more and more frequent. If we could compare with other type of complaint, we do not have too many of them, because platforms do comply what they promise. But of course, the risk is high in terms of consumption safety. Just Christmas lights without the necessary labels might result in a fire. Then regulatory challenges will be that in Latin America we can understand that we should regulate these platforms so they can be part of the formality of trade. Reaching final points in my presentation, I would also like to give you this information. It's a case that's been prosecuted by an European court in AliExpress. The European Union has demanded the Chinese company to be registered and follow the parameters of the law. Within this, have pressed charges against AliExpress because they do not possess a risk mitigation process in the obligation of consumers not to prove the information provided by the suppliers, not to have proper advertising, not to make the process transparent, and make reports on illicit products. As you can see, the things we have identified on the complaints and what's happening in Latin America's reality matches a lot what has been informed by the European Union. We will we will be paying attention to what's happened with this research, because still there's no determination determined by the European Union investigation. And to conclude, and I apologize for talking more of my time, and as a reflection and as a regulatory framework, we kind of sort of establish three regulations. First place, to legislate on a strict application of the law for protection for consumers, or make suppliers to have a Chilean address. We can, although there have been some changes regarding the responsibility of the middle people, we still need more as a nation and as a region to offer a proper behavior, proper to modern times, to make or to raise awareness in the population when it comes to the cheaper products that entail risks. Buying cosmetics or appliances through this type of platform may damage not only people but also the environment. And finally, I have to say that we need to increase audit, particularly with the new routines or tendencies by the vendors. So we need to strengthen customs officers, SERNAC, in the search of audit and the integration of technologies such as X-rays at the customs offices or others. Regulation, actually, if we can have a stance as a region, we might meet the needs to protect consumers. This is it. Thank you very much. Thank you very much, Guillermo, for your presentation. Thanks to the three speakers of this panel and the interesting reflections they have suggested during this panel, Professor Isler, around the preventive challenges we have, particularly in our legislation, with the deficiencies she has mentioned, and the importance of the role of the information in that space. Ricardo also referred to present times in El Salvador around the alerts and the regulatory framework being implemented, and Guillermo describing what happens in the cross-border trade with these platforms, which are more and more important to consumers. It's a reality, and probably it will be more important in the coming years, even probably more than the traditional trade. So thank you very much to the three of you, and a big round of applause.